Good afternoon, everybody. My name is Chris Justice. I'm an employment lawyer with Samfiru Tumarkin. And as always, I'm here today to hopefully answer as many questions as I can. So for the next half hour, please do, if you've got a question relating to your employment, maybe something's going on in the workplace, maybe you've been asked to sign a contract, whatever it is, definitely get your questions in. And as I say, I'll do my best to answer as many as I can live today. Just before some of the questions come in, I typically like to start off with, maybe a news story of the day or a topic of the day. This time around, I wanted to quickly address the issue of non-competition clauses, non-competes. I know a lot of people out there have signed contracts with these non-competition clauses in them. Some people still today are being asked to sign contracts with non-competes in them as well. But for those of you in Ontario, what you should know is that dating back to 2021, so a little over 4 years from today's date, the Working for Workers Act bill was made, and that made most non-competes, non-competition clauses illegal in Ontario. So now there is legislation that says, for the most part, employers cannot include non-compete clauses in any new or existing contract. They can't ask you to sign a contract after you've started or after you've left that says you can't compete with certain companies. And if you refuse to sign a contract with a non-compete, then they can't retaliate against you, the employer that is. They can't sort of say, we're putting you on a suspension because you don't want to sign this non-compete, or we're letting you go because you don't want to sign this non-compete. So now there's been these added protections that have been put into place. But again, for the most part, non-competition clauses have now been made illegal. Now, there are a few instances where a non-compete can still be upheld or can still be enforceable. One example would be if you are an employee who would be described as a sort of a C-suite executive. So you could be a CEO, a CFO, maybe president of a company, vice president. So there are certain positions where non-competes may have some applicability or enforceability still. But otherwise, as I say, non-competes now in this province are void. They have been, and so essentially they don't have any legal effect. Now, before the legislation came out, before the province had declared most non-competes to be illegal, there was still a big hill or a big mountain that companies had to climb in order to get their non-competes enforced. So a lot of people may have, let's say, signed a contract before the non-competes became illegal, maybe in 2020 or before. There is some question mark over that as far as whether a contract that's that old or older, if it's got a termination or I should say a non-compete clause, whether it would stand in court. So this was the case before the ban came into play. Companies trying to argue that their non-competes were enforceable, that they were reasonable, and employees arguing that they weren't. And even before the ban came into effect, the vast majority of non-competes were not deemed enforceable, were not going to be upheld, or actually had been decided by a judge that they wouldn't be upheld. And the reason why, even without a ban, a lot of these non-competes kept falling by the wayside is because the courts didn't appreciate, in a lot of those cases, how restrictive the non-compete clause was. So if you've got a non-compete, for example, that applies worldwide, as opposed to maybe within a 5-kilometer radius of your company, courts are going to look at both of those situations very differently. Obviously, the worldwide non-compete is typically going to be viewed as more unreasonable. And this would have been the case before 2021. There's also a time sort of factor involved. So if you were signing a non-compete that says you can't compete with the company for 10 years, 15 years, even 5 years, even less than that, just a couple years, a lot of the times the courts would find these non-competes to be unenforceable on the basis of how long they last, versus, let's say, a non-compete that was in effect for maybe 4 to 6 months after you've been let go. So from a geographic scope sort of thing, The courts were examining that from a time perspective. The courts were examining that and still do. For those that do still have non-competes that may be upheld, the courts are still going to be looking at how broad of a scope it is. You know, the more narrow it is, the more time limited it is. If you are, let's say, a CEO or a CFO, the more likely it's going to be upheld. But in my experience, the vast majority of non-competes that I've looked at have always, for the most part, been very long in duration. They've had a big geographic scope, so not just, you know, a 5-kilometer radius, but maybe all of North America. And they basically say you can't work for any business that competes with ours in this region. So if looking at it, you think, well, that's going to eliminate 99% of my work opportunities, then the odds are it's going to be unenforceable. If you look at a non-compete and you think, well, that might only take away 2% of my work opportunities, then again, courts may look at that as being more reasonable. But I think either way, if you've signed a contract with a non-compete after 2021, unless you're that exception, you're pretty good to go. If you've signed one before 2021, still a very good chance that the company's not going to be able to rely on it if they want to. But either way, you want to give us a call if you're sort of in that gray area. Maybe you're wondering, you know, does this have applicability in my case? Is it going to be enforceable? Do I have anything to worry about, or not? Is the likelihood that a court is just going to cast it aside? So that's sort of my little primer on non-competes. But if anyone out there wants more information on non-competes, you can feel free to give us a call. We can have a consultation. We can kind of go through sort of all the ins and outs when it comes to those risk factors and what you should be thinking of moving forward. I've got another topic I wanted to talk about dealing with automation and companies sort of removing people's jobs due to automation, due to AI. This is something that's coming up a lot in the news, and it's been the case for quite some time. As technology is sort of advanced, a lot of people are losing their jobs because they're being told that their job is being automated, or maybe AI stepping in, or we've got, you know, this system that's just going to automatically input the numbers, so we don't need you. So it could take a whole number of different forms in terms of technology replacing people's work. But if you are in a position where you've been notified that you're being laid off, or that you're being terminated due to some sort of AI or automation sort of thing going on, you're still going to be owed your full severance. So even if it's legitimate, even if a company is not lying to you and it says that it's replaced you with this AI or this piece of technology, that doesn't prevent you from being able to go after that company for your full severance. And you want to make sure that before you are signing off on any paperwork, any release, anything like that, especially if you've been let go, you definitely want to give us a shout, because depending on who you are, in a case like that where you've lost your job due to automation, you could still be looking upwards of 24 months in terms of severance, depending on your situation. So for those out there that are getting affected in this way, you definitely want to give us a shout, so we can at least kind of make sure you're making the best informed decision, whether that's to accept the offer that the company is proposing, or to engage in some kind of a negotiation, which, to be fair, most of the time you're not going to be getting your best offer. You're not going to get probably anything close to your best offer. So you do want to get an employment lawyer involved, and then they're going to be able to handle it and get you the maximum amount possible. But I'll talk a little bit further about that. I do want to get into some questions. So I've got a question in from Holly, who's trying to understand how non-compete clauses work for co-founders in Ontario. So if a co-founder leaves, can we legally include a clause preventing them from joining a direct competitor anywhere in Canada for 2 years? So I mentioned earlier in the beginning that there are a few types of positions where non-competes may still be enforceable. Particularly if you're in a CEO, CFO, president type role, or there's another scenario I didn't mention, which was if you sell your business and become an employee of the person or the people who bought the business, a non-compete could work there as well. I think the same can be said potentially for a co-founder. There does seem to be, a bit of a different lens put on these types of positions. And I think that to the extent you can have a co-founder sort of, you can have leverage over the co-founder in terms of the non-compete. You do still want to make it reasonable in terms of how long it is, its geographic scope, and just the type of competition you're trying to prevent. So I'll see clauses that will say you can't compete with our competitors for 2 years in North America, but they don't maybe define what type of competition. Can I be a front desk person? Can I be a janitor? Because technically you would be working for a competitor. So that's where the language, I think, of the non-competes comes into play. In terms of a 2-year non-compete, that tends to get into the territory of unenforceable. A lot of times you'll see maybe a 6-month or a year-long non-compete being more likely to be upheld than a 2-year. And then in terms of competition anywhere in Canada, again, I think it depends on what that means exactly. So if someone were to sign a non-compete in this manner, preventing them from working for 2 years in Canada or working for a direct competitor for 2 years, how many direct competitors would there be? Is this person who's signing the non-compete, is that going to eliminate, the vast majority of their opportunities for work? Or is there still going to be a lot of availability there? And when I say opportunities, I don't mean just for any job. I mean a job that's similar in nature, right? So if I'm, let's say, an employment lawyer and I lose my job and I'm asked to sign a non-compete, let's say before they were banned, if the non-compete said, well, he can't work as an employment lawyer in Canada for 2 years, that's going to pretty much eliminate my ability to get an employment law job. And that's typically what most people are going to do. They get let go. They're going to probably try to look for a job that is similar in most respects to what they had when they left or when they were let go. The person may have a transferable skill set. They might be able to work outside of that one particular area. So it kind of goes in some regard towards how big of an impact it'll have on the person. If they're a co-founder of this business and they want to be a co-founder in a different business, or maybe just a C-suite executive in a different business that happens to compete, how much of those types of opportunities make up what's available out there. So I think it'll just be a matter of making sure that your language is good in the clause. So even a misplaced word or comma can sometimes affect the enforceability of clauses. So that's one reason why you'd want to get a lawyer involved. But the second is to kind of go over those factors in terms of scope and length. Again, 2 years, it's a bit on the high side. Typically, a lot of times when I would look at clauses before the ban, there'd be a decent chance, pretty good chance that a court's going to say 2 years is too long. And then in Canada, again, it just depends, because if there's only 10 opportunities in Canada that are similar to what that co-owner had, and this is removing those 10, which then forces that person to have to go, maybe well outside of what would be considered comparable in terms of a job, judge or a court may frown on that too. But I think maybe some more information is needed from you, Holly, because, I definitely want to make sure to craft the best non-compete and also a non-compete that this person will be agreeable to signing as well. But thank you for your question. I'll move on, though, to Beth, who is saying that they were on schedule for 2 hours, and they were wondering if there's a minimum amount of hours assigned to a worker per day. So it's not clear totally how many hours, if this was the situation at all times, or if your hours were reduced. A lot of times people will work a job maybe at 6 hours and then it'll be chopped in half. And those people need to know that they have options in a situation like that. They may be able to deem that change, cutting your hours in half, to a constructive dismissal. But in terms of hours, minimum hours, at least in Ontario, there's a 3-hour rule that gets talked about quite a bit for minimum pay per shift. So that requires, as far as I understand, employers to pay their employees for at least 3 hours in a given shift, even if they work less. So, they may be working their 3-hour shift and get sent home after 2 hours. They still would have to be generally paid for the 3 hours. So that's sort of that 3-hour minimum rule. And so it looks like, Beth, in your case, there's a dip below that. So maybe another situation where you give us a shout so we can kind of figure out what's going on, make sure that there's no violation of any ESA, any Employment Standards Act regulation or legislation, and just get a better sense of what the context is with you and your employer. But it does, on the face of it, seem like there could be a problem for sure. I've got another question in from James. They're saying that their employer didn't schedule them for this week. Usually they get about 30 hours, but things are so slow and he randomly gave you the week off. Is this allowed, or what should I do? Yeah, so I was just mentioning with Beth, there are cases where you've got a shift, you've got a set schedule, and then all of a sudden it changes. And so if it changes to a significant degree without your consent, then, you definitely have the potential there for a constructive dismissal, because basically if you've signed, let's say, a deal where you would work 30 hours a week and you've been working 30 hours a week consistently for a while, and then all of a sudden you're not on the shift at all, you've basically lost now 30 hours. I guess the question is, why did the change happen? Is this an isolated thing where it's just 1 week? Or is this something now that could happen the following week or the week after that or the week after that? Because once you start cutting away at someone's wages or their hours by more than 10%, a lot of times the courts will look at that and say, that's a constructive dismissal. It's a termination almost by action rather than by words. So he's saying things are slow. You randomly gave the week off. The problem is that even if that's true, and even if there are legitimate business reasons for, let's say, laying somebody off temporarily or cutting their hours temporarily, it still doesn't mean that the employee has to basically take it and accept it as it is. There are going to be options. Now, if it's just the 1 week off and it never happens again in the future, that might be one thing. But the idea of sort of, now being in a situation where things are slow and there's more likelihood that your hours are going to get cut off or chopped away, that's not something you want going on for a long time, if at all. And as I say, it could be easily a constructive dismissal. You may very well have the right to go to your employer and say, look, whether what you're saying is true or not, I've been working 30 hours consistently for this amount of time. Now there's been this significant change. I'm not agreeable to that, and I'd at least try to look for some assurance moving forward that you will get those 30 hours and that this won't be something that happens again or on an ongoing basis. See maybe what the employer says in response to that. And depending on the response, you may be in a decision where you're either having to accept this sort of chopped and changed schedule that might be down 1 week and up the next, and then have to stick with that, or go down a different road, which is to say, this has been a big change to the terms of my employment that have been in place for X number of months or X number of years, and sort of take a stand. I think before taking that stand, though, you want to give us a shout, just so that we can kind of line everything up for you if you are thinking of exiting that situation. Because if you are constructively dismissed, for those out there that find themselves in a place like this, you're going to be able to, in most cases, get your full severance as though you'd been let go. So it's almost a way to exit a situation as though you're almost leaving, but get treated in the same fashion that a terminated employee would get. But thanks for your question, James. I've got another question in from Bro, who's saying they worked at a location for 6 years. They're offered 12 weeks of severance. Is this enough? I would say on the face of it, without any more information, it doesn't seem like it's enough. 12 weeks of severance would be just under 3 months. And it's quite possible for a 6-year employee who's been let go to get more than 6 months. There are cases where a 6-year employee who's maybe in their 50s or 60s or older, who's got, a higher position, let's say manager or the C-suite executive type level. I mean, I've seen 6-year employees get 8 to 10 months. To be fair, it's probably on the higher side. That's assuming some things. But even for someone who's middle-aged, making, let's say, $50K a year, working at a company for 6 years, I've still also seen a lot of cases where these people get 6 months of severance. So at 12 weeks, that's less than half of 6 months, which is 26. So there's probably a good chance, Bobo, that you are not getting what's deserved in your case and that you're just essentially getting the bare minimums. There are certain bare minimums that people are entitled to when they're let go, regardless. And assuming it's a relatively big company you're at, 12 weeks to me looks like just the bare minimum. So I wouldn't say it's enough on first glance. I'd say give us a shout. Maybe you can send us a copy of the severance offer, whether you've signed any contract. Sometimes what people sign, of course, can affect their entitlements, but in general, no, it's not enough. You could get potentially double, if not more. And so I guess to that end, I'd suggest you give us a shout. I've got another question in from Monty, who's saying that they're in sales and their employer changed their portfolio. They removed all existing clients and they gave them to another salesperson. And then they gave me all potential clients. Is this a constructive dismissal? Definitely could be. I mean, look, you take away a portfolio, assuming that portfolio was making a relatively consistent amount of money. You take that away, you replace it with all these prospects, right? So not guaranteed customers, let's say. Now you've got to start, seems like, from ground zero, from the bottom up. And I would imagine in sort of expanding that new portfolio you've been given, you're not going to be making anywhere near what you were making with your pre-existing portfolio. So that's going to affect maybe not the time you spend on your job, but it seems like it's going to affect the money. And so I guess a question would be, how much is it going to affect your money-making ability? Are you going to be able to get back up to speed within a few months, or is this going to take much longer? I think definitely on the face of it, a chance for that to be a constructive dismissal. Definitely could see an argument being made that this is a significant change to the terms of my employment as I understand them right now. Again, I'd say I'd want to look at any contracts. If there's something in there that talks about customers or this or that, don't know what the company's saying in terms of the rationale behind doing this to you. But yeah, definitely the potential for a constructive dismissal. So you may want to give us a shout as well so we can kind of set up a consultation. I've got another one in from Jack-o'-lantern who's saying contract limits severance to BC ESA. I assume he's talking about British Columbia Employment Standards Act. 10 years, sales, age 50 plus, terminated due to corporate downsize. If I can't negotiate a fair settlement with a lawyer and have to go to court, what are the chances of success? Well, I'm going off of your statement that the contracts limits your severance to what's in the BC legislation. If you're correct, then there's probably not a whole lot you can do. And it probably wouldn't make sense for you to go to court or go through the litigation process if you're correct. And I say if because a lot of people do have contracts. A lot of people's contracts do talk about limiting severance. And a lot of people think by reading it, that must mean I'm therefore only owed what's in the BC Employment Standards Act. Maybe the contract says we're only going to give you what's in the BC Employment Standards Act. But even still, 80%, if not more, are not worded in the way they should be. The contract doesn't limit it. It may try to. There might be language in it that says we are giving you no more than X. But still, in those cases, 80%, if not more, myself or another lawyer is able to pick holes in the contract and basically get it to be pushed aside altogether, which then opens you up to your full common law severance as a 10-year salesperson in your 50s, which could be a year or more, versus employment standards, which might be, which is just a fraction of that. So I'd still, unless you've had a lawyer look at it already and they've said that the contract is airtight, I'd still want to look at it just to make sure. Because there is a big difference between what the Employment Standards Act says and what your potential full common law entitlements are. I mean, we're talking tens of thousands of dollars, or even more. So depending on what that differential is, it could very well be worth it to go to court, but it will come down to that contract. And without having looked at it, it's hard to say what the chances of success are. So that's kind of the big factor there. The only other thing is if you were to find another job, let's say you were let go yesterday and you found a job somewhere else 2 months from now, not going to make sense likely to go to court or take that risk. If, on the other hand, you're concerned that maybe due to your age or the market, that it's going to be several months, if not longer, before you find another job and you're going to go unemployed for a lengthy period of time, then that's going to weigh a bit more in favor of going to court. But it kind of depends back to that contract, what it says. So either you've got a lawyer, and if you do, I would imagine they're giving you the right advice in terms of the contract, but just don't assume that because there's a contract that talks about severance, that you're dead to rights. But I appreciate your question. I've got another one in from Samantha, who had an accident at work 3 years ago. They were written up for it, accepted the blame. There was another accident last week, and they were blamed and fired, no severance. So I guess, okay, so the first accident, fair enough. You're written up for it. You accepted the blame. People moved on. Doesn't really seem like much then happened until recently you get into another accident. You're blamed and fired. No severance. So it's relatively rare for companies to get away without paying severance. A lot of times they say they've got just cause, or they say that you've done a bunch of bad things or things that are bad for the company, and that they're saying this is cause, and they're letting you go and they're not giving you anything. But even in cases where it looks like the allegations or the accusations are serious, a lot of time in my experience, I kind of do some digging and I find out that it's just not the case. Or even if it is the case, it's still not enough, or it's not bad enough, I guess I'll say, to have the company avoid paying you severance. So again, relatively rare, limited situations where they can get away without giving you anything, unless you've stolen or there's this huge breach of trust. They can't trust you anymore. But if it's an accident, if it's something that's not even intentional, maybe it was a mistake, something inadvertent, going to be very hard to fire somebody with no severance. So I would give us a call, Samantha, because it's just, statistically speaking, it's rare for companies to make out that and be successful. And when you use the words accident, it does seem like they're trying to maybe pull a fast one on you. And I think the last thing you'd want is to kind of walk away and leave a bunch of money, maybe tens of thousands on the table. So give us a shout so we can kind of flesh it out in more detail. But yeah, I appreciate the question. And then there's a follow-up one from you, Samantha, in your previous write-up. Is your previous write-up enough for them to say I'm not owed anything? No, not necessarily. I know if they've got a bunch of warnings or write-ups on somebody, sure, that could in general increase the odds that they'd be successful in their sort of viewpoint. But it's not 2 strikes and you're out. Again, it seems like there was an accident in both cases. So even if there was a write-up, it kind of depends. Is that related at all to the most recent accident? But no, just because there's 2 write-ups doesn't mean they can get away with it. I've seen cases where people have written others up for 3, 4, 5 times, 6 times, and they're still getting severance. So it kind of depends. Again, it's not sort of a one size fits all, but I wouldn't say just by that alone that they can get away without paying you anything. I've got another question in from Human Kambach. They were hired as a customer service rep, but they were moved to Sun Life to do dental claims analyst work. Same pay, but totally different duties. It sounds like a constructive dismissal type of a case. Talked about dropping in pay and hours, but also changing someone's duties. So again, if I take me, for example, I'm an employment lawyer. My company comes to me and says, hey, Chris, we want you to be a legal assistant or front desk. Again, maybe the pay is the same. Maybe they tell me they'll pay me the same, but the duties are clearly very different. It's not what I signed up to do. And so even if my hours and pay and benefits and everything's the same, but then what I'm actually doing day to day is not like anything I've done before, especially if I've been in the role for a while, company cannot generally just switch things up on you like that. Now you're going to be doing a completely different job. Without your consent. So you've typically got to consent. You've got to sign something that says, I agree, you can do this or you can do that to me. But if not, then that's another scenario where you could potentially take a stand and say, no, this is a big change. I didn't sign up for this. This is what I signed up to do. And then I got paid XYZ to do this. Now you're getting rid of this and you're moving in something else. Never agreed to do that. Very happy to do what I've been doing, customer service rep. I've been doing it. Happy to go back to that job, but not agreeable to this new dental claims analyst role. because it's a significant change. And I'd always prefer people to chat with me or a lawyer first before having these big back and forths with the company. But that's in essence kind of what the position would be. And then the company would have to respond to say, yes, no, or maybe so. But at that point, you've said your piece. So all you can do is hope that they go back to how things were. And if they don't, then at least you've got a record in terms of showing your lack of consent, I guess, for a better lack of a better phrase. And then, potentially treat that as a constructive dismissal and go after the company for your severance. But that'll do my time for today, everyone. Thank you very much for other questions. For those I didn't get around to answering, we've got another Q&A going on tomorrow. You see down below there with Septon. So he'll definitely be able to answer any further questions you have. Also, if you want to just book a consultation or give our firm a call further to what we've talked about today, absolutely do so. And I'll be back very soon, I'm sure. But do take care, everyone. Enjoy the rest of your Monday. Bye for now.